So my topic was employment law. I'm an employment and labor lawyer, and James is helping me out here. So I had 5 employment law takeaways, but again, feel free to ask questions as we go. The first is to make sure that you have a good employment contract with your employees. So in that employment contract, it makes good business sense to contemplate the end of the relationship at the beginning. As you probably know, it can be quite expensive to terminate somebody, particularly if you don't have a good termination provision in your employment contract. So this is something that can be managed from the outset through a good and enforceable termination provision that will allow you to make changes by terminating employees who aren't working out at kind of a minimal cost, a fair but minimal cost. Because if you don't have a good provision, then it can end up costing you quite a bit of money, both in legal fees and potentially in damages that you may owe to the employee. So it's, I think, really important to get the relationship off to a good start by having a good employment contract that contemplates all aspects of the relationship, including the termination. You'll see the second bullet there is that in drafting the termination provision, you will want to make sure that you take care to ensure that it is enforceable. Because if your termination provision is, if it provides less than is required by the Employment Standards Act, then it will be considered to be void, and the employee will be entitled to quite a bit more than you were anticipating as the employer. In addition to the termination provisions in the employment contract, you will want to address other issues, the wages and the pay that the employee is entitled to, the hours of work that you will be expecting the employee to work, how much vacation are they entitled to, when are they entitled to take vacation, is there a bonus or an incentive plan? If so, you'll want to, I think, spell that out, including provisions about giving you, the employer, discretion to determine whether bonuses are paid, and if so, how much will be paid. Some of you may have independent contractors working with you as opposed to employees, or you may have both independent contractors and employees. And with independent contractors, you have to think about different types of clauses that you will want to have in the contract. For example, people sometimes don't think about this, but you will want to make sure that the independent contractor has coverage for WorkSafe, so that if he or she is injured in performing duties for your company, that they are covered for WorkSafe. Because if they're not, then WorkSafe can come after you as the employer to pay whatever health costs are associated with the injury that they've suffered. So it is important sort of at the beginning of the relationship to consider having a good employment contract that covers all of these elements. So I can sort of stop there and see if anybody has any questions before moving on to the next. Sure. With
smaller businesses and more entry-level positions, I have a policies and procedures manual that everyone needs to read through, and would that suffice for a small business? Or?
I think it's better practice to actually have a contract with each employee, and that contract can say the employee handbook or the policies do apply to the employee. But I think it is much better practice to actually have a written contract with each employee.
It's not interesting during startup stage to have a contract that includes even job descriptions and stuff, because it's a living document. It's constantly evolving. So we've kept it more sort of general in the beginning with the policies and procedures manual.
Right. And I don't think you need to be overly specific about job duties or about job descriptions.
Does that need to be in the contract?
No. I mean, you can just say we'll assign you duties that are as required or that are consistent with the position that you are hired for. But I think certain things you will want to have kind of nailed down, and one is a good termination provision, because you can, just for example, there are decisions from our courts which provide that employees who have only been employed for a year or less than a year may be entitled to 6 months of severance. And that can be very expensive for an employer, and that could easily have been avoided had the employer had a contract which said, we can terminate you by providing you with the employment standards amounts, which in that case would be 1 or 2 weeks as opposed to 6 months. So it's a little bit of an investment up front to make sure you have a good employment contract, but it will save you for sure. So for things like vacation, they change after 5 years.
Vacation pay and timing. Okay.
That's right, but termination actually changes with each year of employment under the Employment Standards Act. the employee gets another week, up to a maximum of 8 weeks. But one sort of common misunderstanding is that a lot of employers think that the Employment Standards Act amounts for severance are all that an employee is entitled to. But if you don't have an employment contract that says that, then the employee is actually entitled to common law notice of termination, which is quite a bit more than the Employment Standards Act. So that's why it's important to try to have a provision which minimizes the amount of severance.
I feel like I need to leave right now and go right now. I have to go.
Sorry, go ahead. Yes, sir.
Do you have any recommendations for seasonal or like very casual employees who are only going to be there for a couple weeks, like picking fruit or something? You're probably not going to have an employment contract with them.
Right. I think that's right. You probably just want something very simple, saying your start date will be here and your end date will be here, and during that period of time, we will expect you to perform these duties, and you'll be paid this much. Yeah. If you tie the severance to the Employment Standards Act, and I always say it should say, upon termination, we will pay you what is required by the Employment Standards Act and no more. And if you ensure that it is actually tied to the Employment Standards Act, then you should be fine. A lot of contracts will say we will pay you what is required by law, and that would include the common law, which provides for this greater entitlement. The other sort of catch is that if you have existing employees who are already working for you and now you want to change their employment contract to incorporate a minimal severance provision, then you have to give the employees what's called fresh consideration in order to make that contract enforceable. So with existing employees, you have to give them something. It can be $5, it can be $10, but it has to be consideration that they're receiving to enter into the new contract, which has the minimal provision. Otherwise, your attempt to change the contract won't be enforceable. Yeah, I think it depends on the position. I think obviously the more senior position you have, I think to be fair to the employee, you'll want to offer something more than the Employment Standards Act. But with sort of entry-level positions or people who are just starting out, you might want to tie it to the Employment Standards Act so that if you do need to make a change, you'll be able to make that change in an affordable way. You can, and this can become a bit of a morale issue as much as it is a legal issue. So let's say you have an employee who's been with you for 10 years and they don't have a written employment contract and there's nothing that says what they will get upon termination. And then you as the employer come along after a seminar like this and say, okay, now if we terminate you, you're only going to get 2 months' pay. And accept this $5 from us as consideration to make that change and sign here. Well, if they accept that $5 and they do sign here, then that contract will be enforceable. But you may have a very unhappy employee who feels like they're getting kind of screwed over by the company. So you have to kind of judge whether it's worth it to you to make that change if it's going to have a bad impact on morale. But so from a legal perspective, yes, you can change the contractual terms or incorporate new contractual terms as long as you give fresh consideration.
I was going to say, Mike, and if they don't sign, is that constructive notice and they get reasonable something or other?
So they don't have to sign. And if they don't sign, then the decision is back to you as the employer. Okay, what do I do now? They won't sign. Do I want to give them notice of termination now because they won't sign? Or do I just want to leave it? Because it would not give you just cause to terminate them simply because they're refusing to sign something that they don't have to sign. And I can actually back up a little bit even before that. Probably should have done this in the first place. When you terminate an employee, you may have just cause. So if an employee has engaged in serious misconduct, if they have stolen from you, or if they have lied to you, or if they have threatened you, or then you may have just cause to terminate them, which means you don't have to pay them anything. But if you just think they're not doing a good enough job, or they're not quite getting it, or you think there's somebody else who may be better, that usually isn't just cause, and that's where you do have to pay either reasonable notice or the amount that you have in the contract. It definitely makes sense to ensure that your contractors do have coverage for WorkSafe, whether you're dealing with an individual or whether you're dealing with another sort of company that is providing their own employees to be contractors for you. You just want to make sure that there's WorkSafe coverage, because that can be a very, very expensive issue. Like if they're working in your premises and something falls on them and they become hurt or seriously hurt, and you think they're an independent contractor, But WorkSafe BC may conclude they're actually a worker, they're actually an employee of yours. If they make that determination and they're not covered for WorkSafe, that can be extremely expensive. You want to make sure they actually have it so that you can require them to get it and then provide you with proof that they are covered. But oftentimes, employers will engage people who they consider to be independent contractors, but in fact, they may be employees. Even though you call them an independent contractor, WorkSafe may consider them to be an employee, the courts may consider them to be an employee, and you just want to make sure, with an abundance of caution, that whoever is providing services for you has WorkSafe coverage.
That's the only way around it.
Yeah, make sure they have it, yeah. Otherwise,
Who pays it?
with a contractor, normally the contractor would pay it. Yeah.
So the same with like EI and stuff, if the government deems that they're coming to your workplace 5 days a week,
Right.
you know, but you're just paying them a flat fee, they can say, oh, they're actually an employee and make you pay the employer portion.
That's exactly right, for EI and for CPP. Those are pretty contained costs because it's a maximum of a couple of $1,000s a year. WorkSafe is where you got to be really nervous because if somebody becomes seriously hurt, they may be requiring medical attention for the rest of their lives. And if you were supposed to have them covered for WorkSafe and you didn't, you can be on the hook for that. It can be extremely costly. So that's one takeaway for sure, I would say.
Can I just ask another question then? So I've got a contractor, but she works out of her home. So would she still need WorkSafe even if she maybe tripped over the dog?
Well, how many hours a week is she working for your company?
Only about 6.
Yeah. In that case, I mean, probably not.
Okay.
I hate it. This is being recorded. You might use it against me, but you know. So get that WorkSafe. There's a case out of our Court of Appeal where an employer came along midstream during an employment relationship and tried to make a change to the employment relationship like that. So it would be a change where the employer said, from now on, if we terminate you, you will only get 2 months severance. And that wasn't in the contract to begin with, but the employer just brought that in midway through the employment contract. And then years later, the employer terminated the employee and said, we only have to give you 2 months notice in accordance with our contract. The employee said, no, when you made that change, even when I signed that contract, I didn't receive any consideration for signing that contract. And the earlier terms and conditions of employment continued, even though I signed the new contract. And our Court of Appeal agreed with that and said, to have an employee agree to something that may be to their detriment midstream during an employment relationship, you have to provide that employee with some consideration for them to have accepted that deal. And so that's why the concept is called fresh consideration, and it can be $5, it can be $10, it can be anything like that. And it sounds like a really technical thing to do. It is a technical thing to do, but if you don't do it, then your new contract won't be enforceable.
So really
So-
just like $5.
Yep.
Give them money to get them to sign.
And you need to give them the $5. I would give them a $5 check so you can prove you've given them the $5. And you write that right into the contract.
But you've given them the $5
Yeah.
for fresh consideration.
That's right.
Let's talk about that because we have the existing employee contracts, and the time where they'll change is when we do give them a raise or a title change or something like that. So in that case, you would not need to do the fresh consideration because that is the fresh consideration built in.
No, because it sounds like they're getting a raise under their terms of their contract anyways. It sounds like that's sort of in the ordinary course of the contract. I would really recommend you actually give $5 or $10 or movie tickets or something as fresh consideration, and you write that into the contract.
Okay.
That just closes off a potential argument that the employee may have to try to get out from under the contract. Well, it's not bribing them. The courts would say you're offering them consideration to agree to a contract. And for a contract to be enforceable, there has to be offer, acceptance, and consideration. If you don't have the consideration, the contract's not enforceable.
But you don't have to do it with the initial contract.
That's
If you have
correct.
a new employee, they're coming in, they're agreeing to that.
Absolutely.
then you
That's
don't
exactly
give
right.
them a movie ticket.
That's right.
Okay.
That's right. Exactly.
If you're hiring someone in a different province, does that add complexity to the employment contract or cross-border?
So, and they would work in that different
They
province?
would work in it.
So there, I mean, each province has its own labor laws, its own Employment Standards Act or an equivalent of that. And I always recommend to our clients, because I really only know about BC law, that you'll want to get advice from a lawyer in that jurisdiction to make sure that whatever your contract is going to be fully enforceable in that jurisdiction. Right. So if you're going to employ somebody in Alberta and you have a sort of template employment contract that you've been using in BC, then I would always recommend send that employment contract to the lawyer in Alberta or Washington State or wherever the case is, and just have that lawyer review it to make sure it's enforceable. Because there's always these little pitfalls that I may not know about in Alberta or Ontario. For instance, this whole fresh consideration issue, that's not written down anywhere in a statute. And so if you don't know it, you don't know it. And so it makes sense to just have that review done by the lawyer in that jurisdiction. Yeah. Yeah.
Is there anything in common law regarding fresh consideration about the minimum that you have to pay an employee?
No.
Regarding, doesn't matter how, if they've been there 10 years or 20 or 5?
Correct.
You know, just as a human being, though, I think they used to have quirkies that a peppercorn is good enough. You know, one peppercorn. And Mike, I know Mike, he's a cheap guy. He would use a peppercorn. I would give them a nice present, you know, $100 or something.
Yeah.
That really, so it feels like consideration to them too, personally.
Yeah. So this slide is about restrictive covenants, and the most common restrictive covenants are things like a non-competition clause or a non-solicitation clause, and I'll explain the difference between those two. So you may be employing somebody in a pretty senior capacity or in a sales capacity, and they're dealing with all of your customers. And what you may want to prevent is that salesperson leaving your workplace and going and joining a competitor and now trying to solicit business from your customers, who you feel that you've built up your customer base, and you don't want your salesperson working for your competitor knocking on the door of your salespeople to try to get business for your competitor. So our courts are very, very reluctant to enforce what's called a non-competition clause. That would be one where you would say to your salesperson, you cannot work for a competitor, period. Our courts find that to be generally offensive and unreasonable, and deprives a person of earning a livelihood. So it's extremely difficult to have a restrictive covenant of a non-competition clause enforced. But what our courts will enforce more frequently is a non-solicitation clause, which says, okay, you can go and work for a competitor, but you can't solicit business from any of our customers when working for the competitor for a period of time. Maybe 6 months, maybe 9 months, maybe 12 months. Kind of depends how long that person has been with you. Sorry, go ahead.
What if your clients follow that person though over to the other?
Yeah, if the clients choose to go without being solicited by then there's not much that you can do. There are some cases where the departing employee is prohibited from either soliciting business or accepting business. Okay. But that's a little bit more aggressive. There have been, I think, 2 cases which have upheld that, so it's possible. It's something to definitely think about. The more common clause is one that prohibits the departing employee from soliciting business from your customers. But even there, our courts are often looking for ways to strike these clauses down. And so now it seems that your clause has to say, departing employee, you cannot solicit business from any of our customers that you dealt with when you were an employee with our business. So it's getting kind of narrower and narrower. But these are clauses, a lot of people really want to have a non-competition clause, like you can't go and work in the restaurant business within 100 kilometers of Tumbler Ridge, but you can put them in your contract, but chances are a non-competition clause will not be enforceable. And a non-solicitation clause will only be enforceable if it's reasonable.
So again, service-based business,
Yeah.
we have staff that we hire that could absolutely be in a position to take clients and service them on their own. So we have this in place, but how do I know if it's properly drafted?
Well, I think it's good to have it reviewed by an employment lawyer,
Right.
just to make sure. Because what happens is the law constantly changes, and a set of facts will come before the court and they'll make a decision, and now there'll be a new case that puts greater restrictions on what is acceptable and what is not acceptable. So it does make sense to constantly have, or regularly to have them updated and reviewed just to make sure that they're okay. If you had a good non-solicitation clause with your employees, there'd be nothing to prevent them from going to work for a competitor, but there may be something to prevent them from soliciting business from your clients if they do go and work for a competitor. Yeah. I don't know if that answers the question, but you can't really stop somebody from trying to poach away your employees.
Right.
Yeah, that's what I think. Yeah.
Are you able to, so you mentioned that the period of time for the non-solicitation has to be congruent with the time in which they've been employed. So it should be part of their termination paperwork as opposed to part of their contract?
No, so it should be part of their contract in the first place, and it's not necessarily congruent with how long they've been with you. It's just that the court, one of the considerations the court will look at in deciding whether the clause is enforceable is how long is the duration of the non-solicitation.
So 6 months.
And so, and what the court will look at, and it's hard to sort of draw a line around what's acceptable and what's not, but they'll say all that you can do as the employer is to protect your business to the degree necessary. So if the court may consider 12 months is too long, then they'll strike the whole thing down. They won't say, well, your clause is too long, but had it been 6 months, that would have been okay, so we'll give you 6 months. You have to draft it to the minimal protection necessary for the employer. So, you may be inclined to go for a longer period of like 12 months or 18 months, but you should be thinking, well, we want to make sure this is enforceable for some period of time, so a lower period of time might be better to make sure it is enforceable.
You're starting to creep into my area a little bit too, and that's a good thing. But if Mike weren't here and I were presenting this, I think I would have tried to say everything as well as you did. But I would say, from my perspective, on sort of the IP side, is you're trying to protect the legitimate interest that you have as a company, and so you have to look at your own business. What's your sales cycle? How long is it before that relationship will go cold between your former employee and your customer? And so if your sales cycle is once a year and you talk to everybody December the 1st and they order a fruit basket, you get a longer non-compete than if it's something that's turning over all the time. So you've got to look at your own business when you do this.
That's exactly right.
And I would say just one little quirk too is it might not be from soliciting anyone who they ever had any dealings with or is ever a client of the firm at any time. It might be the people who they personally dealt with or the people they dealt with in the last year of their employment or something like that. Sometimes they're kind of narrow, aren't they?
Yes, they are. They are.
Include prospects or no?
It can include prospects, people that they've dealt with themselves as prospects. Yeah. These things, just so you know, they can be very expensive to try to enforce, so it's nice to have them in the contract, but the reality is, okay, if somebody leaves you and is now competing or soliciting business, are you going to want to spend $20,000, $30,000, $50,000 to try to enforce it? So that's real consideration that comes in terms of legal fees. Okay, for sure. Okay, appropriate use policies. So this is where a lot of employers will now have an appropriate use policy, which deals with what the employees are allowed to do on your computer system and what you're allowed to do in terms of monitoring what your employees are doing on the computer system. So, for example, a lot of employers will say, you're allowed to use the computer system for personal use or incidental personal use. You can't use it for any inappropriate activity, which may include gambling, may include disclosing your confidential information to somebody. It may include downloading or sending pornography. It can include a lot of things that you may just want to prevent your employees from doing, period. And you may want to say in the appropriate use policy that we, as the employer, own the system, and we have the right to monitor what everybody is doing on the system. And so you, employees, should not have an expectation of privacy in what you're doing, because you need to know that we can monitor what you're doing. And if we find that you're doing anything inappropriate, then you may be terminated. So it's not a bad idea to have this, because if you don't have it, the employee may argue that, look, what I was doing on the system, either on my lunch break or my coffee break or after hours, was my business, not yours. And when you went and looked at it, you invaded my privacy and you started snooping around with my personal information. So it does make sense, I think, to have an appropriate use policy if you have employees who are using the system for personal use or even incidental personal use.
I have a question about that, actually. I had a franchisee, and we have our own email system and every network use it. And we had to terminate her. And I kept hold of the email address, but I actually want to get rid of it because it's taken up quite a lot of space on the driver and stuff. Like, am I legally allowed to do that?
To do what, sorry?
To delete her email account now. Now she's no longer a part of the company.
Yeah. Yeah.
I wasn't sure.
Yeah.
I just kept it in
Yeah.
there thinking, like, what should I do with it?
Yeah, I think so. Or you could, maybe save it to I'm not up on technology. I don't know if you'd save it to a CD or to a hard drive or something so that
So
it would be preserved if needed,
Right, okay.
but to free up the space.
Okay, good.
Okay. This one's good. Avoiding a rush to judgment. So, what I often see is a company will be faced with a situation. You think an employee has engaged in some sort of wrongdoing, and the employer will believe that the employee has engaged in this fundamental misconduct. There's no possible excuse for it, so we're going to fire them. Boom. And often the employer may be wrong, and often the employee may have a perfectly legitimate excuse or explanation for what they did. And so I think it's really important when you're faced with a situation where you believe the employee has engaged in misconduct, that before you shoot first, you actually do conduct a fair investigation. You ask the employee for his side or her side of the story. You try to gather all the facts that you can gather so that you can make an informed decision about what to do. Because people's jobs are very important to them, and often if they're kind of fired when you believe they've done something wrong and they actually haven't done something wrong, it can be pretty devastating to them, and they can then sue and obtain significant damages against you in court. So it's really important, I think, to sort of step back a little bit and conduct a fair investigation, really give the employee an opportunity to tell his side or her side of the story so that you can make an informed decision. I brought a few examples of employers who didn't do that and the consequences, just so that you can appreciate that. 2:45. Crap. No example. Not leaving you any time. No example. Okay. No example. And that feeds into the last one, which is what I call an ounce of prevention, where it does make sense, and we're not just trying to drum up business, but it often does make sense to call a lawyer earlier rather than later. Just to say, okay, this is what's happened, this is what we think we should do, what do you think? That sort of ounce of prevention is always less expensive than dealing with a problem after it arises. Sorry.
Is it a good idea to have an employment lawyer on retainer, or should you just kind of call them as you may need them?
I think call them as you may need, yeah, generally.
Now, so I know that I appreciated when I came in that Mike was going to be peppered with questions, and I'm going to get to the end and he'll say, any questions, and we'll all file out of here. But employment is sort of the direct and daily concern that one of the big ones you have. And I'm going to talk to you today a little bit about something that's always in the background, but can leap forward in importance as you go along. So hopefully, here we are. So these are the things I want to talk about quickly. The first is just developing an IP vocabulary. So we're all talking about the same thing. There's a lot of people, what's a copyright versus a trademark? They've infringed my something. We'll talk about different kinds of IP. I'm going to talk about why you might register it and what the costs are and some of the implications, just at a very high level. Then just bring it down to what's important for most of the people around the table here. Then I have something I'm calling miscellaneous traps for the unwary. And then I liked Mike's line about 5 takeaways. So I got 5 intellectual property takeaways. So this is a list of the kinds of IP there are, and you will have heard these. And I think maybe just looking at the kinds of businesses here, I'm going to run through these fairly quickly. The patent is typically you're going to be less important for this group. And so I'm going to focus on copyright, which means the expression you have, any kind of expression in writing or otherwise. So all of that work product you have, your employment manuals, the pitches that you do to your customers, any of those kinds of documents, that's copyright, and you want to preserve your right to that and to reuse it. Trademark is the name, the logos, and the trademark that you use to identify your business and differentiate it from other people's businesses, one of the most important things around the room here. We have one possible industrial design, I think, where you're talking about the aesthetic aspects of what's otherwise a functional good. So you can get some protection for or just the way something looks for the ornamentation of it. And then finally, trade secrets. So your customer lists, your pricing, and all those important key documents that you keep confidential and you don't want anyone else to know. Those are the kinds of things you can protect. So why register? Some of these you don't need to register. Some of them you have to register in order to enforce them. So first is patents. They're going to cost you $10,000 or tens of thousands of dollars to obtain one, and take maybe a year or two to get it. It'll be enforceable for 20 years, and you can't enforce it. You can't enforce the protection of your idea unless you have a patent. Copyrights are really cheap. You don't have to register your copyright. Its ownership is created by virtue of the creation of the copyrighted work, and I'll talk about who owns it in a minute. But if you do want to register it, there are some benefits to registration. You can get damages for infringement. Critical documents you reuse all the time. Maybe a strategy document that you would be really pissed off if somebody else was using it. You'd say, this is my special method and way we do things, and this manual, we're going to register the copyright in this. That's something you could do. So that process is really cheap. It's like $25 to get a copyright registration. You can probably do it pretty safely yourself through the Canadian Intellectual Property Office. I don't usually recommend that for most other things because there's so many little traps for the unwary, but you can probably get through it in a copyright. Now, trademarks can cost probably $2,000 or $3,000 realistically to get a registration, including about $550 of government fees. And there are some benefits to registration. You do have rights just by virtue of having used a mark. So each of you is running a business. Your business has a reputation, and where you have that reputation, you have trademark-like rights to it. No one else can pass off on your goodwill. So that's the basic of where copyright law started, or trademark law started. But as time's gone by, we created these registrations, and there's big benefits to that in terms of there's a presumption that you own the mark. There's a presumption that it's valid and enforceable, that it's not someone else's mark, or that someone else is going to have to prove that you ought not to have that mark, or that it's not enforceable. And it's also enforceable not just where you have a local reputation, it's enforceable all across Canada. So if you have a restaurant in one city, no one else can open a similarly named one across the country. So there's big benefits to that.
Is there a statute of limitations that we have to go back to them and say, you can't have this? Or, because we're not in the Ontario market yet, or do we just, if we're granted the trademark, do we just wait and they're basically risking whether or not we're going to do that?
Well, the longer the two marks coexist, the less the likelihood of confusion between them. So it is better to act sooner rather than wait. There's nothing in law that says you can't wait, but it gets harder and harder to enforce the longer the time goes by.
But I'm assuming it's a legal battle if I do try to enforce him to change his name or something.
Yes. Yeah. Okay, industrial designs, these can cost thousands of dollars. They're not done as frequently as you might expect. Probably this water bottle was registered as an industrial design, believe it or not, because nobody wanted that exact copy, or the Head & Shoulders bottle. But the average, most ornamented works, people don't register just because of the time involved in registering, the costs. By then, it's been knocked off in China and sold around the world, and it's all over. Sorry about that. So I'm going to talk about confidential information, trade secrets, the customer list, the kind of things we talked about. There's no registration process for that, and those rights can last forever so long as they remain secret. Okay, so what's most applicable here? I think we have a good sense that the things I think each of you should be protecting is the intellectual property of the business is generating, and your reputation and goodwill. So the first thing I'd say is own your business's work product, the copyrights and the inventions that come from it, and you're going to need, maybe I should say that the copyright of the work product that's created by your employees in the course of their employment belongs to the business as a matter of right. There doesn't have to be a written assignment. If you hire someone to make inventions, that's their job, those inventions will belong to the business. But in any other circumstance, you need to have an assignment, and that assignment needs to be in writing for it to be binding. So So it's a really good habit to have in your employment agreement assignment of all of your patents and copyrights, all intellectual property, confidentiality provisions. And this is going to be one of the traps of the unwary, is that if you don't put those provisions into your agreements with your contractors, the contractors own their own work product because they are their employer, not you. And so you need to actually have that in writing for you to own that. So finally, the trademark represents your reputation and goodwill. It's what your customers identify you by. If you don't have the rights to that, it can be devastating to your business. And I'll give one example is if someone else registers that name, your exact name, somewhere else in Canada as a trademark, after 5 years, their registration becomes inviolable, and they, believe it or not, they can actually force you to change your name. It doesn't have to be completely changed, but you have to make some changes. So now for some miscellaneous traps for the unwary. Your business name in the company registry in Victoria does not protect your trademark. So I think a lot of people think that if I've registered in Victoria, then I'm good. But that, I mean, you could register Coca-Cola in Victoria, nothing would happen. But just try and use that trademark, see what happens, you know? So if you fail to enforce your trademark, it becomes unenforceable over time, and there's lots of examples of marks that have lost their trademark meaning by just use by too many people over time. And if it doesn't point to one person, if it points to 2 or 3, then there's no reason that same trademark can't point to 4. So your competitors get the closer the names, the less protection you get, the narrower it gets for you. I put down spending money on registrations before you need to, and then because I'm a lawyer, I put or waiting too long. I think that if you're a true startup and you've got 100 battles to fight, maybe registering your IP and spending the money on that isn't one of the first ones. I would spend the money on, or the effort on, really searching and making sure I wasn't infringing somebody else's IP when I got started. There's no point putting all the work into growing your goodwill and then find out, crap, I have to change my name because it was too close to somebody else's. So put that effort in up front. And then once you've built that goodwill and you have a little bit of money, and you'd be really mad if somebody took a similar name, that's a good time to register it. Then I mentioned failing to own the work product of your employees and contractors. So that's, I would say, the most common trap I see people falling into is not getting a written assignment from their contractors and not really owning what the work that's been done. And when there's a dispute, then contractor goes away and there's not a darn thing you can do. Okay, 5 intellectual property law takeaways. We've covered these in different ways, but pick a distinctive mark that points to you alone and is memorable.
So I have a question with regards to the what we do within our business.
Yeah.
Like we provide.
So I guess whatever you created belongs to you, but that doesn't mean that if it's a colorable imitation, a copy of someone else's work, that you haven't infringed their copyright. So if I'm going to use Monopoly, since we're all familiar with that. Like if you say, hey, that Monopoly game is a great idea, I'm going to go create something with a totally different name, and instead of real estate development, I'm going to do drug development, and I'll have little test tubes hopping around the board, and we'll spin a thing instead of, there's a way to, you can take an idea and a totally different expression, and that doesn't infringe someone else's copyright. That's your work. If you just take the Monopoly board and photocopy it and change it to duopoly, you're going to have a problem. So putting that infringement part aside, if you as a group under one roof have collectively developed a game, it's a copyright work. If that was done in the course of employment by the other people there and they were employees, then it belongs to the company. And all that I answered, hopefully, the question that was asked. Oh, good. Okay, so the second point here is getting invention assignments from employees and copyright and invention assignments from contractors. Okay, I beat that to death. When you do give work product to people, I would make sure you're licensing it to them and not assigning it. They do the opposite of what you're going to be asking for assignments from small contractors. But you need to reuse your work product. So if it's, you know, whether it's the games or if it's your manuals or whatever it might be, you want to give people a right to use it and not assign your work product at any time. And you might want to say, and you have a right to, you have to keep this confidential and mark it confidential so that they're not copying it or giving it away to other people. Next is consider the reach of your business over time. I'm sure some of you have global domination ambitions. And that's a good thing, but you should know that most intellectual property rights arise on a country-by-country basis. Not everything, but most does. So if you want to protect that name you have, once you've got the domain names, then start thinking about registrations here, and that'll drive registrations in other jurisdictions, where usually the English-speaking world is where we start for people. And finally, I'm going to echo one of Mike's points here a bit. An IP lawyer, a patent agent will generally meet with you to discuss your idea, issue, needs without any charge or obligation, at least once.